clients and wish you lots of luck in the spring market. Jules and I are super happy to be part of your NRG huddle this morning, and we're super grateful to Randy, Jeremy, and the whole team at NRG for supporting us at Stewart Title with business you've sent our way and allowing us to participate in your events throughout the last year and this year so far. So Jules has gone way back with many of the realtors at NRG, and we have seen a lot of tremendous support from all of you over there. So our way to give back to you is to give back through our resources, help things to be smooth at the closing table, and offer added value services that may support your marketing efforts and trying to find new business out there. Just a little recap before we get into the main event with Jules. I just want to overview some of the services that we offer at Stewart Title of Minnesota. We are global. We've been around about 130 years, and we have over 7,000 employees with Stewart, which is amazing. We have a really great financial record. I think the end of last quarter was like an A or A minus. So, I mean, we're staying strong through this, interesting market we've had the last couple of years. We have some really great closing resources for you. We have our Minnesota Stewart locations across the metro, and we also have access to e-closings, remote online notary. We can close at Regis office spaces across the metro, and we can close at your location. So we're very flexible with where we can close it to accommodate you so that it's most efficient for you and your buyers or sellers. Some of the things that I'm just going to recap on real quickly are some things that I think set us apart. We have wire fraud protection at Stewart Title. We were one of the first underwriters nationwide about 4 or 5 years ago to go out and get a partnership with Certified, which is basically wire fraud protection up to $1 million. So it really covers that. It's just an effort to prevent fraud with wires. And if you have more information on that, Jules can go into more detail anytime that you'd like. We also offer interpreter services at the closing table. There is a fee for it. We charge $100 for that, unless you're hearing impaired, excuse me. We have about 300 languages that we can accommodate at the closing table, including sign language, Hmong, Spanish, Somali. There's 300 languages. So just reach out to us and let us know if your clients ever need multilingual services present at the closing table. And then we also have some nice things like Home for Heroes. If you ever have a buyer that is part of the Homes for Heroes, like a policeman, firefighter, nurse, if you go to their website, there's a list of different types of occupations. We will take $100 off the closing fee for that. We do like to do a lot of educational events through Stewart. We'll do farming and lead generation classes. We'll do financial updates. We'll do lots of different. Last year we did a couple new construction events and a top performing realtor event. So we've really loved to do that type of thing. So if there's ever a class that you'd like us to put on for you, we do have a Bloomington training room that holds up to 40 people, and we're more than happy to put on a presentation for you if you'd like to learn more about any of these services. We also offer lead generation and farming to support your marketing efforts and finding business out there. And I would be your go-to for that. So if any of you are interested in looking for homeowners or renters that best match your target market, you can reach out to me directly, and we can meet for coffee or a Zoom or whatever works best for you, and we can try to customize a lead list. It's very affordable. It's $27.99 for a lead list up to 1,000, and that is our more expensive of the three services. And that does come with some scrub numbers against a do not call list, email content, and much more. So that has been very popular with our realtor and lender partners for the last 4 or 5 years. And then one other platform that I thought I would let you know about, if you don't already know about a very popular real estate marketing website. It's called Breakthrough Broker. And we're not really affiliated other than just knowing that they're a reputable company, and they offer really very popular realtor tools, such as just listed, just sold postcards, flyers. A couple weeks ago, I sent out to some of you the expired listing letter template that was very well received. I had a lot of realtors saying, oh my gosh, I love expireds. I love to go after them. Can you send me your letter or the letter from Breakthrough Broker so that I can compare it to mine? But their website is breakthroughbroker.com. And I think they might still have the free platform. I'm not sure. I haven't checked lately, but they did do a lot of, they have a lot of resources for printing and designing your own postcards, flyers. And some of it is free where you can just cut and paste your data, put it into this really cool flyer or postcard, and then go to your local mom and pop printer shop. Otherwise, the way they make their money through this company is through printing. So you could check out their website. They're pretty popular with a lot of realtors that I know. If you'd like more information on any of these services, you can reach out to Jules or I anytime. She's really great about taking phone calls, just to discuss title scenarios. Sometimes you have challenging issues that you're like, what should I do? Or what, she loves that. So you could reach out to her for title scenarios, fee quotes, new title orders, jelaine.setter@stewart.com. And she goes by Jules. And then happy to meet for coffee anytime anybody here is interested. So now I'm going to step into the main show, which is Jelaine Setter, Jules. She is a senior escrow officer with Stewart Title. She has a wonderful, amazing assistant named Sonia Brown, and they've been together over 20 years, probably about 23 years at this point. And they can manage closings throughout the state. And she's an absolute, I consider her like a walking dictionary of knowledge, anything pertaining to title and closing. And she's smiley, friendly. She knows how to get things done. She's like so professional. I love to gloat and brag about her all day long when I can. And so today, Jules is going to overview some topics that I think you're interested in learning about. Sellers and or buyers signing or in, trust related, LLCs, power of attorneys, divorce or death with them on title, and then quitclaim deeds. So again, thank you. I'm Kathy Schildrup with the business development side of Stewart, and I'm happy to work with you anytime. So here you go, Jules. Thank you.
Well, thank you, Miss Kathy. As always, now I'm embarrassed, but thank you very much. I have been doing this 26 years, so that's kind of my background in case you don't know who I am. I think some of you have been on these calls. Quick question, Jeremy, what kind of a time do I have today?
Time of what? Sorry, Jules.
What kind of timeline do I have today?
Yeah, well, you have the full hour if you like.
Hey, me. All right. Well, good. Let's get started then. So let me just back up one quick second here, and we're going to talk about how these things, why trust, what affects your side of the transaction. So you're part of the transaction. So on a standard title company title commitment, what we've got here, I'm going to show you what we've got here at the top. This is the proposed insured. This is who actually owns the house right now. So we're going to talk a little bit about signing in trust, buyers and sellers. Sellers, if it comes up as somebody in trust, in this trust or at that trust, that's where you guys, if you're doing the listing, are going to need to let your people know that there are going to be a few things that they're going to need to provide. Because what happens is where we get that information for who is entitled is from the county. That's what's of record at the county. So somebody being in trust, there are some additional documents that do need to get filed if you're going to deed out of a house or do a mortgage or anything like that. Because of course, the house then is, the trust owns the house. Obviously, the trust can't sign for itself. So anything that you do that needs to be made of record at the county, whether it's a deed, whether it's a mortgage, whatever, is going to require a certificate of trust to be filed. And that only gets filed once. What that does is it encapsulates what the terms of the trust are. Who are the trustees? Who are the settlers? Who are the who can actually sign for the trust? How many people need to sign for the trust? A lot of times when people actually go into title in the trust, the only thing you need to do that is actually do a deed saying the trust. So in my case, I've got, I did this, I do some Facebook things as well. I have the Howell Family Trust, if you can see that. I was doing a Rocket Old School with the old school TV show thing. So that's Thurston and Lovey Howell. They do have a revocable trust. So chances are very good when they put that into trust, all they did was deed into the trust and nothing else was filed. So the certificate of trust is a vehicle that the state of Minnesota decided to use, it's been quite some years now ago, but what it does is it encapsulates the terms of the trust. So I know that sometimes, like if you have a seller and it's like, oh, you're in trust, you know, you're going to have to get some information to the title company. The reason they're going to have to get some information to the title company is we need to know what the terms of the trust are, because that is how we're going to draft the documents that we draft. Stewart Title, they do allow us to draft certificates of trust if we have, hopefully, like an older certificate of trust that their attorney did back in the day, or if we can, if the information set out clearly in the documentation. There's there's quite a few title companies that don't allow that, but we have the underwriter here in house, so to have things approved on our end. But that certificate of trust, the reason that the county decided or the state decided to do that is because before that certificate of trust exists, which once again just kind of gives general terms of the trust, we actually had to file the entire trust document. And as you guys all know, this is all public record. So that's probably not something you want. You don't want, you know, everybody in the world knowing that your house is, you know, in this trust and all the other things that are in the trust. So if you do have particularly sellers that are concerned about giving their information, I just had this happen to me about 4 months ago, where the sellers absolutely did not want us at the title company to have their information about their trust. Well, where the rubber meets the road is the county has to have some documents that actually show who can sign for the trust, because of course the trust can't sign for itself. So we had to actually get to the point where we said, well, I'm really sorry, you know, you're not going to be able to sell your house unless we get this information, or you go to an attorney and have them draft a certificate of trust, which of course they didn't want to do that either, money wise. So that's kind of what you need to let your sellers know and be prepared for, is that we're going to ask for some information. It's not because we want to dig through their trust information. Once again, hopefully they do have an old certificate of trust. Minnesota did change their format probably about 15 years ago. So if there is one of record that isn't compliant, generally speaking, the county wants us to draft a new one that's compliant. The new compliant ones tell how many people does it take to actually sign that trust. Can one trustee execute those documents, or do they need multiple people to do that? That's the kind of information that are contained in the certificate of trust. So just let them know it's not anything scary. It's not anything unusual. We don't want to dig through all their stuff. But what we need to do is be able to draft documents or get documents that we can record with that deed that's going to make it a recordable deed. Now, for you guys, when you're actually doing a listing and the people tell you, okay, well, you know, our house is held in trust. Hopefully, you know, you guys ask the questions, who owns the house? Is anybody else on title with you? First thing you're going to want to note is this is out of the standard Minnesota Area Realtors Purchase Agreement. It is line 259. If you can see that, there is a spot for a trustee's deed. That's the one that you're going to want to check on your purchase agreement. Because once again, anything that's not going to be compliant with the information, you're going to end up going back and doing amendments to the purchase agreement. Nobody wants to go back and reinvent the wheel and bug everybody to have to sign things. Lenders are particularly picky about this, having that as a trustee's deed. There are buyers that are picky as well. Sometimes it'll fly under the radar as just a deed, but the technically correct thing to do would be to mark that on 259 to mark it as a trustee's deed. So then your question is, okay, how are my people supposed to sign? So you need to know who the trustees are. Generally speaking, even if it's only one person is required to sign, if they're both there, available, able to do so, we generally speaking have both trustees sign. Usually if it's like husband and wife, family type of trust, it's just going to be the husband and the wife as the trustees or something like that. There's a couple of different ways that you can do this. So technically the most correct would be number 3 here, the Howell Family Trust, and then on your signature lines, you'd have Thurston Howell III and Lovey Howell as the signers. But, you know, on the purchase agreement, you should say who's actually the seller. And technically the trust is the seller. The trustees, of course, are signing for the trust. But you can also, on a purchase agreement, you can do it any of these ways. Thurston Howell III and Lovey Howell as trustees of the Howell Family Trust, without the as, with, any sort of variety of that will get you where you need to go for who needs to sign that purchase agreement. Once again, even if their certificate of trust or their trust information says that only one of them needs to sign, it's, the county will accept that and that's fine. But we tend to see that you run into a lot of problems with like underwriting issues if there is a loan on the other side. So, they'll look at it and go, oh, okay, where's the certificate of trust that's getting filed? Well, we show them that. Well, there's two trustees. Well, only one needs to be signing, but there a lot of times we do see that get kicked back. So you're going to want to you just make sure that you do it as compliant as you can on the front end, so you don't have to go back and reinvent that wheel. The other thing that you might want to prepare your sellers for, and of course, we're the title company, we're going to also tell them this, but the proceeds will have to go into an account that's in the name of the trust. And the reason for that is, when you sell a house, you can't just go, oh, here, I've sold my house, but I'm going to, Thurston Howell owns it, but we're just going to give all of the funds to, the captain or Gilligan or someone, there are ways to do that. If there's arrangements or divorces or whatever, there's a little bit of documentation, but generally speaking, as title companies, that's our responsibility, is to make sure that the proceeds go to the people that actually own the house. And it's not hard if they don't have an account. They can just certainly go to the bank and start one, or but they are going to need to have that information. They're going to need to have that account, because otherwise there's really no way to get the money to them if they don't have an account in the name of the trust, which is the one that actually owns the house. So by the way, forgot to mention it, if you have questions at any time, just jump into the chat. Kathy keeps an eye on our little chat questions. So if you want me to clarify anything or need additional information on anything, or just even have a side question, please feel free to jump in and we'll get to those questions as well. So, and basically the only reason that they do have the trust is it's an estate planning thing. So you just want to make sure that you do it correctly, particularly because of that as well, because generally speaking, it is set up as an estate planning vehicle. So you want to make sure that you don't get a phone call, a couple of years down the road where someone says, hey, they sold the house. Why did that money go just to them? Why didn't it go into their trust? That's, it's all part of a, legal estate setup that they've got going on there. So does anybody have any questions about trust? Did I cover everything that anybody would want to know? Going once, going twice? Think about it. Just once again, shout it out later. Now we're going to move on to LLCs. So LLC is, of course, a company owns the property. Generally speaking, we see a lot of them, and I'm sure you guys see a lot of them too in this process, where it's people that do like renovations, flipper kind of situation. Of course, we're going to need documents about that as well, because once again, the LLC itself cannot sign for the property. We have to be able to draft the documents correctly. The name of the LLC has to be correct. And also the signer needs to be correct as well. So for an LLC, you're going to do kind of the same thing that you're doing with your trust information, where you're going to put on that line, you're going to put Joe's LLC is actually the seller, and then by whoever your person is that is the signer for the trust or for the LLC. So once again, you're going to want to let your seller know that we are going to need to have some information about that too, about what is the who's able to sign. Generally speaking, we want the corporate documents. They can forward those to us. We do go onto the state of Minnesota website and make sure that the LLC is still in good standing as well with the state of Minnesota. That's another requirement that we have. So a lot of times it's that sneaks up on people thinking that they're going to need to bring in, once again, corporate docs, articles, when they set the company up, who's actually the signer, because we need to make sure that that there aren't multiple people that need to sign, that there aren't that the person who's saying that they can sign can legally sign for the LLC, because of course, once again, we want to make sure that everybody is doing everything in the legal compliant way that doesn't get anybody a phone call down the road saying, hey, I was, one of the officers of this company and I wasn't even aware that was sold and then you needed my signature. that sort of thing. Most of the time, people know who their signers are. We've run into it a couple of times where people are kind of confused about it, or, you know, aren't necessarily giving the correct information, not because they're trying to like pull any sort of shenanigan, but just because they don't really understand what we're asking. And of course, you're going to want to, forward this on to your title company, and we're always here. Hopefully I'd be your closer, but if I'm not your closer, whoever your closer is, or whoever you're planning to send your file to, can also direct you on what you're going to need, because that's kind of the wild card that we have as the title company. We're not involved on the front end with the purchase agreement with you. So, we do things like this, little educational things like this, just so that you'll have a better understanding of what is going to be required. Because once again, nobody wants to go back and do amendments saying, okay, yeah, now we got to say this person's the signer, or that LLC name wasn't correct. Nobody wants that. Everybody wants to just be able to get those done, not have to go back and reinvent the wheel. And you also want to make sure that you're doing it in a compliant manner as well. One thing I just thought about on the trust thing as well, sorry to back the truck up for a moment. If your buyers are buying in trust, we also need to see their trust information. Now, that doesn't mean that we necessarily are going to file a certificate of trust. That's not required. That's only required when they go to do something that it requires signatures. So anything that is like if they're going to do a mortgage, if they're going to sell, the certificate of trust, if there's not one already of record, would need to be recorded at that time. There's pros and cons to doing it right away. It costs a little bit of money on the front end. Yeah, it's of record at that point. But the wild card is like when the state of Minnesota changed their format, and all of a sudden they're like, well, we really like to have one in the new format, because the newer format set out how many trustees need to sign, that sort of thing. So you don't know going down the road if it's going to end up being a situation where they go, well, yeah, that's not the Minnesota compliant one now, so now you got to file one anyway. So, I generally speaking don't file a certificate of trust if they're not doing a mortgage. If they're doing a mortgage, they need to file a certificate of trust. We would. And an affidavit of trustee, which just is a document that on the date of signing, they still can sign. The trust still exists. Everything is still good and in order. And we would also want to see their trust docs as well, because, and this is very important, we want to make sure that if we are deeding a buyer into title in a trust, we want to make sure that information is correct. Because generally speaking, when you put the name of the trust, you most of the time would put like the date that the trust was done. So under agreement dated, April 15th, 2025, that sort of thing. If you mess up any of that input, then when they go to do something else, they're like, oh, well, that doesn't match the information that was made of record, because the information on the front end wasn't correct. So very important that, buying, selling, whatever you're doing, we're going to need to see some information about their trust, just to make sure that we're deeding them correctly, or we're deeding them out, getting the right documentation so that the county will take that information. LLCs, the reason I backed the truck up is because LLCs are exactly the same situation. We're going to want to see some information about their LLC. Once again, make sure they're in good standing, because, there are people that check into these things, that make sure that people aren't, creating fake entities to launder money, that sort of thing. That's one reality of the world that we live in. But the other one is, we want to make sure that when we're deeding them into title, in their company name, in their LLC, that we get that correct information. So, because it's easier to take a little bit of time, do it correctly on the front end, and that's our job as title people to do that. Sometimes some of these things, if there's errors in what was deeded, can be kind of a bugger to get fixed. And it's going to slow up your process. So just like your buyers and sellers know on trusts and LLCs, we are going to need some backup documentation to show that this is what it is. The trust still exists. The LLC still exists. They're in good standing. Everybody's happy. Everything's good to go. Because you want to make sure that it's done correctly the first time. Because, of course, as usual, this business is a business of referrals, and you don't want people going, oh, yeah, I closed with whoever, and, they screwed up my whole deal. Their title company did something wrong. And the whole thing went sideways, and then, the bad publicity, that's part of it too. You want to make sure that you're doing the best that you can for your clients so that, going forward, they're going to refer you to other people as well. Does anybody have any questions about LLCs? The nice thing about the trusts and the LLCs are it's really not your gig, right? You're not setting it up. It's just the way that they're either going into title or they're going out of title. It's not something that other than you want to do your purchase agreement correctly. So on your LLC, you're going to do it exactly the same way as you're going to do a trust. You're going to say the XYZ LLC by whatever their name is. If you know their throwing things around my office here. If you know their what their capacity is at the company, you could put by John Smith, member, John Smith, owner, John Smith, president, that sort of thing. You could ask them like, what standing do you hold in the company? So you could put that behind your comma there, just so that everybody's aware, everybody knows who's signing. And once again, if that's a seller that you're dealing with, a lot of these things, the underwriters now for lenders are asking for backup documentation on all of this stuff now. Things that even up to like a couple of years ago, we never would have gotten a request for. Now, going through the underwriting process, the lenders are like, well, we need to see documentation that says that John Smith can sign for this company. We need to see documentation that shows, that Thurston Howell and Levy Howell are the trustees for their trust. And in that case, we would give them like the certificate of trust that we were planning to file or one that was of record. And then in the case of an LLC, we would, generally speaking, have to send them the corporate documents so that they could see that was correct. I'm assuming that this is all, everybody, I don't know if you've heard about FinCEN, financial crimes enforcement. It's becoming a big deal. End of this year, it's going to be a bigger deal. On a next one, we can maybe talk about that a little bit more. Stewart's been very proactive in getting what's going to be needed for that. That is basically, they are now asking for documentation and backup and a lot more information about who the people are that are selling houses, buying houses, to make sure that no one is actually laundering money or, running some sort of a scam. So that's just something that you need to have, need to let your people know that there could be backup documentation that needs to happen if they're going to be LLC or trusts. So I'm going to get off that subject now. Let's move on to our powers of attorney. So powers of attorney. Okay. Power of attorney, that is, of course, when someone grants the, FinCEN has been canned by Trump. Interesting. That's interesting. Anyway, that just popped up on my screen. All right. So powers of attorney, moving forward. Power of attorney, that is someone is granting the ability to someone else to actually sign for them in one of these residential real estate transactions. One of the things the biggest thing about the power of attorney that we as title companies want you guys to know is that if they have never used that power of attorney with the transaction, or if they're buying and a power of attorney is signing for them, we're going to need the original power of attorney. We can't record a copy. The county requires original documentation for that sort of thing. It's like a mortgage. It's like a deed. The county wants original signatures. So we have to have the original of that power of attorney. We will get it recorded. We will return it to whoever, wherever we got that power of attorney from. But you want to let your buyers and sellers know that if they're planning to use that power of attorney, we're going to need an original. That can be a challenge for people to give up that original. One of the things that I've started to do is hold it aside, maybe get it made of record as soon as possible so we can return it as soon as possible, and then send the rest of it on for recording after that or whatever, depending on what kind of a power of attorney it is, because there's a couple of different situations where a power of attorney is going to get used. One of those situations is the people aren't available to sign. One of those situations, and generally speaking, you're going to see this on a sale. If you're a listing agent, the person who owns the house is no longer able to sign. whether it's due to some sort of a condition where the signatures, Parkinson's is a big one we see it with. They can't physically sign, or they're not mentally capable of signing anymore. So the powers of attorney are kind of a big deal. The other situation we see powers of attorney on is on the buyer side. And on the buyer side, there's some reasons that some people, want someone else to sign for them. But you guys as agents need to know that lenders are now needing to approve those powers of attorney. Most of them do. And part of that approval process is it reasonable that they need to use a power of attorney? There are lenders that will question why this power of attorney is being used. So the point of that is that not being able to take time off work, not wanting to take vacation time. I've had lenders, the underwriting department of lenders, throw it back and go, that's not, they don't want to take time off work to buy their house. That's not a valid reason to actually use a power of attorney, and have denied them using it and said they need to come to closing. Valid reasons, illness, once again, some sort of a disability, being deployed, that sort of thing. Those are all things that are going to get approved. Other situations, some of them will not get approved, and it's all a lender specific thing. Some lenders are fine with it, and some lenders absolutely say nope. They come to closing, or they don't buy the house, or they don't get the mortgage, because that's their stipulation on it. So if you have somebody signing a purchase agreement, either way, as a buyer or as a seller, you're going to want to do the same sort of thing that you did with like your LLCs and your trusts. You're going to say, whoever it is, as attorney in fact for, so in this case, Lily Munster as attorney in fact for Herman Munster is the way that you would want to put that on your purchase agreement, just so that you're noting why Lily is signing, in this case, probably twice, probably two people buying the house. She's going to sign, or selling the house, they're going to sign twice. That's the way you're going to want to put that on your purchase agreement, so everybody's on board. And so that once again, when this gets back to the lender and all of a sudden the lender sees, things coming through that have Lily signing both for herself and for him, there's not going to be a question. That they will already know what's going on, and you won't have to go back and do an amendment or addendum to your purchase agreement to show that it's being signed by a power of attorney. One thing, if they're buying and they're using a power of attorney, these are the two ways that usually a lender is going to make the person who's signing for the person sign the lines. So the only reason I mentioned that to you is that, if it is one of those situations where it's like, oh, they already had a hunting trip and they don't want to, not go on the hunting trip or whatever. You want to let Lily know that she's going to end up signing one of these two ways on every single line for your lender. All you need to know about that is that it's not going to be a 25-minute closing. You're going to need to expand your idea of how long it's going to take to close this loan, because that will over double the amount of time that they're going to have to spend signing their documents, because of course they have to sign that whole giant thing. So just a heads up for you guys, and heads up I have had people at the closing table say, if I would have known that I was going to have to sign all this stuff, I would have said, she needs to come to closing. He needs to come to closing. It's like, I don't want to start any domestic disputes at the closing table, but that's the way the lender makes you do it. So just so you guys, can prepare them a little bit. That's what's going to need to happen if that power of attorney is actually approved. On the seller side, on a listing side, if you're doing, if the seller's using a power of attorney, of course, your title company is going to need the power of attorney. And we're going to need to actually send that up to underwriting, just to make sure that it's going to be a compliant and recordable power of attorney. Because if we can't record the power of attorney, we can't record the deed, because the deed's being signed by the power of attorney. So that's our whole focus, is we got to make sure that the county is going to accept that deed. And so that's why we're going to need to see that. Questions, powers of attorney? Anybody? All right. Divorce. Let's talk about divorce for a minute. Divorce and death. So not death and divorce, not death and taxes. Let's move on to that. divorce. If you know people are separated, let your title company person know that right away, because there are timing issues that we need to figure out. It's a different scenario if for us on the title company area, and truthfully for you guys as, well, not as much, I guess, for you guys as doing a purchase agreement. You're generally going to see that on the listing side, of course. People who are getting divorced probably aren't going to be buying a house together. It's going to be more on your listing side, when you're asking them, okay, who owns the house? What are the situations? You're going to want to ask them, any sort of, you can usually tell, I would assume that, we can see it at the closing table. We're like, this isn't a good situation. If they are separated, then we will have them be having them sign as married people, perhaps completely separately. I just had one, a month and a half ago where they didn't want anything to do with each other, but they were still married. So we did have them sign separately in separate signings, but they are still signing as married people. If they are divorced, and this is where you guys are kind of the eyes and ears for us, because you have a relationship with them as your sellers. They will give you a little bit more information than they'll give us at the title company. Sometimes, you're going to know, and chances are maybe you do know the people, or you kind of know their situation. If they're in the middle of a divorce, then we really need to know that, because we need to know like what the timing is. Are they going to end up being divorced? Like we've had ones where the divorce went through like 2 days before closing, which is not optimal, because then all of our documents that we had them pre-sign say that they're married people, but now they're single. Now there's a divorce decree and they're single. So it's easier if we're not that far in the process, or if they're already divorced. If they are already divorced, then what we're going to need is either a copy of the divorce decree, or a copy of what they call a summary real estate disposition judgment, or we call them an SREDJ. And the SREDJ is something that it's been the past like probably 2 or 3 years that the state of Minnesota has gone to that format. And the reason that they've gone to that summary real estate disposition judgment is that otherwise, much like they went to a certificate of trust for a trust, we're going to have to file their entire decree if they don't have that. And that, of course, has all of that other information, but the county needs that information to see who was awarded the house. That's what your summary real estate disposition judgment is going to do. It's going to encapsulate kind of those information that are real estate specific. Who was given the house? Were they given it free of any liens? Is there a marital lien on that property? Kind of a little summary of the terms that are just around the real estate portion of it, so that if they're going to sell the house, they can actually have that made of record instead of their whole entire decree. Because once again, you're going to put out every single thing that's in your divorce decree is going to go out there. And that's not great. So I've seen in the past ones that I've seen for the past year, it's actually the judge, it's written into their actual divorce papers at the end when it comes out as filed, that a summary real estate disposition judgment will be done by one or the other of the parties, so that just to avoid having to put that into public record, because of course we don't have a choice. There's the decree or the summary real estate disposition judgment has to be filed. And the reason for that is the county needs to know why the people who they see as married, which is what is a record at this current time, why are they signing as single people now? So that's why that document has to go in, much like, your certificate of trust saying, why can these people sign for the trust for the house? That has to go in to say, why are they now single? The county looks at all of that stuff and says, hey, that we see them as married, so show us that they're not. So death of a person on title, a little bit more difficult. There are more things that encompasses than like your standard divorce or something like that. Death of a person who's currently on title, depending on how they're on title together or separately by themselves, will determine how that's going to affect you guys. And it really does, even if you're not doing the listing, if you're on the buy side, and you hear from the listing agent, oh, yeah, well, Herman Munster passed away. It was him and Lily Munster owned the house, but Herman has passed away now. That is going to be a bigger deal because you're going to need to know how they were entitled. And you guys, you're like, yeah, that's a title company thing. And yes, that is a title company thing. But for your purposes, if you're on the listing or the selling side, you're going to want to ask your title person, who once again, I would love it if it was me, but you're going to want to ask your title person as soon as the title commitment is done, are they joint tenants? Or is the title going to be okay? Because if they're not joint tenants on that title, it means they're tenants in common. And if they're tenants in common, then there's a very good chance that a probate action is going to need to be done unless there was a transfer on death deed done, something like that. Because once again, at the county, it's showing Herman Munster, Lily Munster. Now all of a sudden it's just Lily Munster. Why? Why is that? And unfortunately, not the same as being, a trust or something else where there's just a document that can be filed. If they're not joint tenants, then a judge has to do, and they have to do a full probate, and a judge actually has to appoint someone to sign for that part of the house, basically the interest. So back at your line 59, if you know that it is an estate or going through a probate, you're going to want to check your personal representative deed box. Those are really the only two that aren't going to be a warranty deed, unless you happen to be doing a random contract for deed, but generally speaking, you guys wouldn't be doing that. Personal representative deed, only if someone has passed away and the thing is going through a probate action, or it's already gone through a probate action and it's held in an estate. And then trustee's deed, obviously, if it's in a trust or warranty deed, is the other one. Those are the ones you're going to want to actually put on there. And then if you know that it's already in an estate, what you're going to say is, once again, Lily Munster as personal representative, whoever has been awarded that personal representative position by the judge is the person that's going to be signing. So it would be the estate of Herman Munster by Lily Munster, personal representative. So that carries the same sort of thing. The only problem is if they're not joint tenants and there's not what they call a transfer on death deed, which is a deed that the state of Minnesota now allows in the past probably 5 years, where if you wanted to say, make sure that your house went to your kids right away, the only two options on that are putting them on title, or now you can do a transfer on death deed. So if both whoever's on there does pass away, you can do that transfer on death deed. But the probate issue is going to be a big deal if that has to happen. So that's the only thing that you guys need to kind of keep in mind. And then I would suggest that you, even on the buy side, you find out from your title company person, is everything good to go with the fact that one of the people that owned the house has passed away. I had a situation, well, it's kind of an ongoing situation now, where I have a seller who wasn't quite forthcoming about the fact of how, when she and her husband 30 years ago bought their house, they were not joint tenants, which we found out. And she didn't do a probate, and because she was told that she didn't need one because they were both on the house, but they weren't joint tenants. And then it turned out, digging into it a little bit further, they weren't joint tenants because this was like a second marriage when they were, in their like 50s, and he wanted his part to go to his family, which really affects your whole thing, in terms of like, you're thinking, okay, she's the seller, she has a mortgage of this much, this is what we're selling the house for, we should be good, she's going to get a couple $1,000s or however many $1,000s. Well, if it's not 50% of what that house value is, there's a chance that the deal could not go through. Because if it comes out of the other side of the probate and it's like, okay, well, his children inherited his half, she's only going to get half of that money and the other half is going to go to the kids. So that's just something that, as listing agents particularly, you want to keep in mind. But as a selling agent, if you know that it's in the process of a probate, or it hasn't even, it's just the person died and nothing's been looked at, you're going to want to make sure that you circle back and say, hey, is this a problem? Are we going to have an issue with this? Because it's going to hold up your thing. Now that one now is going through probate. It's going to be at least a 3-month turn. And we don't know if she's going to end up having enough money to actually close it by the time it comes out of the other side because of the debt that she has. She's got a couple of judgments, that sort of thing. Because you guys know as well that there are judgments that we do have to pay off at closing. She has like two tax liens, one state, one federal, and some judgments. And I don't know if she's going to be able to sell the house now because she's at this probate, depending on how it comes out. So, any questions about probate, about what needs to happen if you have a seller where someone has passed away? One thing to note, we've had people say, oh, but I have a power of attorney for Herman Munster. Lily has a power of attorney. Powers of attorney cease to exist if the person has passed away. Power of attorney is something you can only use if the person is still alive. Now, I've had questions, well, they're in the home and they're not really in a great state. Can they still use the power of attorney? Yes. Power of attorney still stays in force as long as the person is alive. Once the person has passed away, that's when you're going to need to have a personal representative appointed by the court. So power of attorney is not going to help you at all if the person has passed away. Any questions from anybody out there? I'm thinking
Hey,
that
can you hear me? This is Randy. Okay, sorry, I'm in a store and I'm traveling, so I just had to press a certain button because my phone thinks I'm still driving. But I had a question. Somebody called and asked when do they get their 1099? You don't just generate a 1099 at closing, right?
They can be generated at 1099. What most title companies do with that, almost all of us now have what they call a substitute 1099. So even if one is not generated at closing, it depends on the title company, what their process is. If they wait till the very end of the year and they go and they send all of the 1099s, or if they do them individually per transaction. But there's, generally speaking, most of us as title companies have what they call a substitute 1099 that they can take to their tax person and say, here's the information, here's my substitute 1099. It has exactly the same information that their 1099 is going to have. And basically on a 1099, what they're going to see is the purchase price. And then any tax proration, if there was a tax proration on there, buyers assuming some part of the real estate taxes or something. But, a 1099 is going to show you just actually what the purchase price was. So we, generally speaking, in, January-ish, we start to get panicked phone calls. Well, I didn't make $500,000 on the house. Why am I getting something that says that I made $500,000 on the house? And the answer for that is it's because it's a government form, of course, and they're not going to go individually per transaction, just like they're not going to go individually per when you're doing your income tax. You just get, here's all the money that you made, and then you figure out what you owe money on. Same sort of thing on a 1099. Here's what you sold the house for. You take it to your tax person and figure out what your tax implication is. But that's a good question about the 1099s. A lot of companies wait until the end of the year and send them out en masse. And then if you are proactive and you're trying to do your taxes in like November, you can certainly go back to that substitute 1099 document, and that will give you the information that you need as well.
Perfect.
All right, what do we got here? Anything, Sony?
We've got something from,
Yes.
Yep.
Oh, go ahead.
Question on, my ex-husband closed on a house one day before our divorce was finalized. Do you know if he will need me to sign something when he sells that house? The house he bought was not in the divorce papers.
That's interesting that the house wasn't addressed in the divorce papers. If the house was not addressed in the divorce papers, yes, chances are very good. I mean, obviously I'm not an attorney, but from our purposes, yeah, because if he bought it and you, like the title company knows, now these are kind of sneaky situations because we as title companies have seen where somebody hasn't disclosed that they were married and then divorced, whether they forgot it or whether they knew that that person was owed money or whatever the deal is, they weren't disclosed. And, as title people, we only know what we know. And most of what we know is based on what's of record at the county. The rest of what we know is based on talking to the sellers. Did they disclose that they were divorced? I have had people not disclose that they were divorced. I had one guy that showed up with an entirely different wife Fortunately, this was like years and years ago, probably like 15, 20 years ago. And, but he also showed up with his divorce decree. So we had been asking him, is your wife coming to closing, and using her name and all this stuff. And, so yeah. So in that case, legally, yes, you should be signing a quitclaim deed, to him. And you could do that at any time. Like if you're worried that years down the road, you're going to end up being dragged into something if he sells the house and then you have to, sign things, you could proactively do a quitclaim deed to him, with that legal description and just quit claim it. And then it's kind of his problem when he gets to selling the house. Like, is he going to have to explain to the county that he got married? Is he going to have to turn in anything? But yeah, if it's something where you would like to just make sure that you take care of it right away, you could certainly proactively do a quitclaim deed because it could very well be required. I would suggest you do that if that's something that you want to just get it off your plate. The other wild card to that is Minnesota is a marital rights state. So if you subsequently get remarried, he's going to have to sign as well because you are a married person. You cannot sign a deed, quitclaim or otherwise, as a married person. Your spouse has to sign. That's the one to buy, two to sell or refi that Minnesota has. Not community property, but spousal rights state. So yeah, it is a bit, unless my guess would be that he did not disclose that he was married, or they just didn't really care, but my guess would be he didn't disclose. Yeah, if he was legally married when he bought a house, you would need to, you can buy as a married person. It's one to buy, two to sell or refi. So, maybe it was just a thing where he said he could, he was buying it by himself. But you would definitely need to, almost definitely, once again, not an attorney here, but as a title person, I would say that if he discloses that he was married when he did buy that house, that we as a title company would be asking for your quitclaim deed, particularly because it was not dealt with in your divorce decree. If it was in the divorce decree, then there are certain situations where you can just file a divorce decree and that will sever that interest. But yeah, we would be asking for that.
If somebody does a lot of real estate transactions, could they have like a power of attorney from their wife? That's kind of a blanket form to not have to go to 4 closings a year.
Yeah. Power of attorney works across the board. So,
Yeah.
you could just attach put a C attached for your legal description and then attach the legal description of the next one that you're signing for. You don't even need to have like 8 million of them. You could just, I always tell people, if you're going to do a power of attorney yourself or have a family member to do a power of attorney, sign at least 5, because you never know when you're going to need an original and you never know when you're not going to get that original back. If you sell a house, use a power of attorney, or buy a house, use a power of attorney for signing. It will be of record, get with that house. So you could get a certified copy, but there are certain situations, particularly with people that with memory issues, where memory care places want an original of that. So like with your parents, with whoever, if you're going to get in a situation where you're signing powers of attorney, do at least 5 originals. There's no reason not to. Do 10 if you want to. Sign as many as you want to. Sign them all at one time. Just keep them if you want to. The one thing about having someone sign for you as a power of attorney, this is really important, on a property, that power of attorney is then of record on that property. So that person could legally go back and sign something for you on that property. They could not disclose that you didn't want them to do that anymore. Kind of important with people that, are having their spouse sign for them down the road. There's problems, whatever they're doing. They don't want their person to be able to sign for them for any reason. That is where there is actually a form. It is a Minnesota revocation of power of attorney that you would want to file on that property to make sure that that power of attorney was not going to be used going forward. Because once again, as a title company, we only know what we know. We don't know that there's a problem, or, these forms are available on the state of Minnesota website. So quitclaim deeds are, powers of attorney, revocations of powers of attorney, they're all on the Minnesota website. So they could do without even having a title company involved. They could go and be signing stuff. if they could figure out how to draft their own. So you just want to keep that in mind if you're doing a power of attorney, that if you decide that person should no longer be able to have the right to sign on that thing, to be covering yourself, file a revocation of power of attorney.
So Jules, we do have a couple more questions. One is from Curtis. Do you commonly see second homes and investment properties put into trusts and LLCs as a preferred closing method? For example, snowbirds to Florida or Arizona, or even cabins in Minnesota. Also, do you service out of Minnesota properties?
Okay, so good questions. So putting a second home into an investment or a trust, LLC, that sort of thing, it's kind of a preference sort of thing. Tons of people own cabins and they own it in their own personal name. It's kind of a thing of what that is in your personal world. So your personal world, you want a family trust to keep your cabin in your family trust. We see a lot of that. You just have to understand that there are, some, as we talked about with the trusts and the LLCs and all that stuff, there are some additional hoops that you need to jump through if you're going to sign with that. And of course, you go to your attorney and have, things put into the LLC or put into the trust or not in the trust. It's the only benefit, like as an LLC, if you had a one-person signer for an LLC, that might be a benefit to, if you're going to do like a sale or refinance, only one person would need to actually sign that document. But yeah, it's kind of a preference. We see it both ways. And it just really depends on, you'd probably want to talk to like an estate planning attorney to actually figure out what would be the best for your own situation, because it's kind of all over the board. Do we service out of Minnesota properties? Stewart Title has, I think we're in most of the states. Kathy could speak to that. Or we have people that actually use Stewart Title as an underwriter. So even in these states where we don't have like a Stewart Title office, we have people that use Stewart Title as the underwriting portion of their title commitment. That's who's writing or doing the title policies. So yeah. And that's a common thing. Kathy and I will both tell you that we get people, hey, I have this property in Arizona. Hey, I have this property in Florida. What you'd want to know if you're a Minnesota resident and you are a snowbird is with I've got a property in Florida or Arizona, that if you are doing a refinance, you're in Arizona or whatever, you're doing a refinance in Minnesota, or opposite, if you're here and you're, whatever, we can certainly, we have a lot of Stewart Title offices in Florida and Arizona as well. We can work with them to work with you if you're in Minnesota because it's summer, we can actually witness your closing or actually walk through the documents with you for our Arizona or Minnesota or Florida offices. Our Stewart Title Minnesota, we can actually only do closings or write policies, lenders and owners policies for Minnesota and Wisconsin though. We can also do policies in Wisconsin. So those ones we can do closings as normal as whatever. Otherwise, we generally coordinate with people at our other offices. I know that we had a Tennessee office that wanted us to walk through some documents with people who, snowbird down there, and then they'd already come back up here and they're refinancing their place in Tennessee. Our Tennessee Stewart people reached out to us and we said, sure, yeah, we'll walk through their documents for them. So I also do closings all over the state of Minnesota. Oh,
Hey, I got a question now. Well, why not just make life easy and just throw it on a remote close and do it online, so nobody has to drive around anyways?
good question. And the answer to that is, do you have a lender? Because lenders really drive that. Lenders drive the whether or not they'll accept a remote online notary. They also drive, weirdly, some of these lenders will not accept a deed that's signed on a remote online notary. I don't know how. I don't know why they feel like they have the ability to do that, to say, no, your seller can't sign that way. But we started, and all title companies, have started to see that being a problem. So generally speaking, if we're doing the buy side and the seller side says, hey, can you do a remote signing? Can my people do a remote online signing? We go, let me check with my lender, because I don't want their underwriting to throw it back. And then you already had them do that remote online signing. And then it turns out that, no, you can't do that. Generally speaking, in other respects, what we would do then is we can, send a notary pretty much anywhere in the United States. We can actually send a notary to the people, or have a notary go to the people at their house or whatever, which we can do that here as well. Just to make it easier for people. But yeah, that remote notary is a little bit tricky because some of them, we always got to make sure that it's going to be like the county will take those. It's not a problem with the county. It's a problem if there's a lender involved, then sometimes it can get a little tricky, and it's something where we don't want to commit to the fact that we can do that. If they're gonna kick it back and go, no, we won't accept this as a deed that's signed.
So if somebody's off overseas or something, we got to check with the lender for any remote closing.
Yeah. And generally speaking, anybody that's like overseas, if their lender is, if they're doing the purchase themselves and they're doing it with a lender, then their lender already knows that they're overseas. So they're already aware that there's going to be an issue. For our purposes, Stewart title on a buy side, if the people choose to sign remotely, sign their buyer side documents remotely, we can set them up with a remote online signing, and we're absolutely fine with that on a buy side. And then, of course, if we're doing the buy side and the seller chooses to do theirs as a remote online notary as well, even if they're not using us as a title company, we're totally fine with that. On a cash purchase, it's way, way different parameters than it is on a regular purchase. On a regular, if there's a lender involved, then that makes it a whole other level of stuff.
There's a couple more questions, going back to Christy. Any special considerations relative to Wisconsin property closings?
In terms of?
It could have been, maybe if Christy wants to pop on real quick and just add to that.
Clarify what the question is. I mean, I guess the only real special consideration is that they're a little bit different the way that they do their title fees and the way that they conduct their title closings. In Wisconsin, the seller side pays the owner's policy, so the seller side drives the closing. They choose the title company office and they close. Minnesota's kind of weird because we do what they call split closings, where the buyer and the seller could be on separate with separate title companies, and a lot of times they are on separate title companies with separate. In a place like Wisconsin and a lot of other states, it's one title company that represents both sides. So, with a divorce, so it's basically kind of the same sort of thing. There could be the requirement that there would need to be a quitclaim deed because he was actually still married when he purchased the house. And once again, I would say, if that's something you think is going to need to happen, if you're okay with it, if it's just like, oh yeah, I'm fine with it, I just don't want to be bugged down the road when he sells a house, I'd go ahead and proactively do that quitclaim deed, particularly if you have not remarried, because what's going to happen in Minnesota for sure, and I believe Wisconsin is the same, what would happen is that your new spouse, in Minnesota for sure, your new spouse would have to sign that quitclaim deed too, which is kind of weird and awkward as well. So if it's something you're fine with and you just don't want to be dragged into some mess down the road, I would say I would proactively just go and do a quitclaim deed and, take care of it, shovel it off to him and say, here, you're probably going to need this at some point, just take care of it for you and say, I'm not going to, or have it filed a record or something, because you don't want to be bugged down the road. And you certainly don't want to be bugged if you have moved on with your life and you have another spouse. And now your spouse has to sign, because Minnesota to sell a refi. And I believe that with Wisconsin is the same in a divorce situation. I think they're probably the same, where I'm not sure about that because that's kind of not as much of a common scenario. But I believe that they'd be the same and you'd have to actually both sign. Or you and your spouse or whatever.
I'm sorry about that.
No, go ahead.
We do have, so I listed our website for anybody that is Stewart.com for anybody that's looking for out-of-state title. But then also Jacqueline is looking for the actual website that shows the Minnesota state website forms that you were referencing.
Yeah, that's on the state of Minnesota. And I don't know if can I post it on there? I probably can. Hang on.
Maybe that's something we could provide Randy and Jeremy.
Yeah, I can throw that to Jeremy. Mm-hmm. And that's you have to dig through your best bet to do that if you're going to use those forms on your own. Find a deed, find a mortgage, find something that was signed against that property, because one of the things you're going to need you're going to need your legal description. And you can't use the one that's on the tax statements or on the, on the website for the taxes, because a lot of the counties will truncate those and they say right on there not to be used for, legal purposes or whatever. Dakota County weirdly adds things to it. I don't even know what that's all about, but it's going to be not the technically correct legal description. So you'd probably want to find your old deed or whatever, or we have a Stewart Now deal where you can go on and you can property search. You could property search for the deed transferring title, which would also give you that legal description.
And I can be a go-to for that because I have realtors and loan officers that love that access. Anybody who places a first order with Stewart Title, Minnesota, you have access immediately to our website called stewartnow.com. And you can see your orders live time 24/7 like a pizza tracker. So if it's Friday night and you really want to see your title commitment, you can. But then next to that, there is a property profile report feature. And literally you can enter any address in the whole United States and instantly get a report to email to yourself, anybody else. And it's great for listing presentations, but it shows who lives in the house. Like, for example, Joe and Mary Smith. It'll provide you all the data, kind of things that you already see through MLS, which is property characteristics, number of bedrooms, square footage, comparables. You can uncheck comparables if you don't want certain comparables on there. You can expand the radius and the months back. And then right below that, there's a transaction history. And I've used Goldie Hawn's Malibu beachfront property as for NRG in the past, because I wanted to see Goldie Hawn's signature on the original deed, and I did. So you can go back and see the transaction history for every transaction that's taken place on the property. And you can even click on the hyperlink, and the hyperlink will allow you to see the deed, any deeds that the county has provided, which could be the deed that Jules is referring to, and or mortgage, whatever.
Yeah,
So
because that's going to give you that legal description that you're going to need if you're going to go to the county website or state website to draft your own documentation. They also have powers of attorney on there as well. You can draft a Minnesota statutory short form power of attorney on there. Which is what the county wants if you're going to, have one made of record. They don't want like there's a medical durable one. I'm not sure that they're even really drafted that much in Minnesota anymore, because the statutory short form it has a checkbox for real estate closings only, or there's a whole bunch of like personal, financial, all this other stuff that you can check. And then at the very bottom, it's all of the above, that so someone can actually do any of that for you. That kind of thing. So, that's Stewart Now. I was going to say too, it's helpful to you guys as agents, because you can go and check that title commitment if we're doing the buyer side. It's only if we're doing the buyer side. It's only the Stewart produced stuff. But say you're the selling agent and you look at it and you go, wait a minute, why does this say that there's like a federal tax lien for like $200,000 against your seller, and the purchase price is $230,000. I mean, is it really your seller, or the listing agent calls and says, oh, we have a problem. These two people who's on title, and you're like, what are you talking about? And you can go and actually look at that. You shoot an email to your title person too, hopefully me. And I will say, oh, let me look. And then I will, look at it and go, oh yeah, or this is what they're talking about. Or sometimes, between you guys as agents, you're the ones that are ping-ponging that back and forth between each other. If there's a problem here, if there's a problem there, and we're over at the title company going, oh, didn't know that we had a problem. So, you're going to want to, if there's any questions that are big questions like that, you're going to want to like hit up your title company person. Once again, that'd be great if it was me right away. Just to make sure that your title company person is aware as well that there is something that maybe isn't showing up somewhere, or did show up and it's something that we didn't think was a big deal. We've been told that like that judgment or that tax lien wasn't the person who's on title, and then come to find out they're like, oh yeah, that really is our tax lien. So, then we all got to, fall back and regroup and figure out what's going on with that. Anybody else want to jump in with any kind of whatever? It doesn't even have to be pertinent to what we've got here. Any kind of questions that you've got cooking? I don't know that we have a ton of people left on here anyway at this point, but Jeremy, we did not get to the quitclaim deeds, Jeremy and Brandy. Yes, we do have a seller net sheet format on that app. Is it on the app though, Kathy?
Well, you can go to stewartnow.com and it'll provide like what's called a C3 calculator, and it kind of it shows different ones you can choose from. And
Yeah.
otherwise, Jules is happy to do fee quotes anytime.
Yeah. And so for your net sheet, I think that one that we have on the Stewart website is pretty good. There's a checkbox at the top, what you're trying to do, a seller net sheet, a buyer net sheet, and an actual fee thing. I would suggest that if you want to know fees, just hit me up and I'll put together the like for like a buyer side fees, that sort of thing. But if you're looking to do your seller net sheet, I've had people use that one and they say that it's a pretty good net sheet generator. And you're just typing things in there, and then at the bottom it will give you your calculation that you're going to give to your seller. Yep. Yep, exactly. So Kathy can send you that link, and if you have any questions about it, just shoot me an email as well. My email is JULAINE, because my name's really Julaine.setter@stewart.com. If you don't remember that, you can just send a message to Bloomington@stewart.com and say, hey, Jules, I have a question. And that will actually reach me as well. So if my personal is, and then I'll respond off my personal so we can, start a thread on it. But you can always just shoot something to Bloomington@stewart.com. And it's Stewart.com, not Stewart title. It's Stewart.com. So Bloomington@stewart.com, where I'm currently sitting. And that will get to me. So just say, hi, Jules, or whatever, Jules, spell it however you want to. I get it JULES, JEULS, JEWELS, JEWEL. It's fine. I know you're talking to me, and I will get back to you, and we'll figure out how to answer your question. But probably the easier way if you don't remember how to get to me.
And
or Kathy.
Just a quick reminder too, for anybody that wants access to our website, just reach out to me and I'll get you set up. If you haven't already placed a first title order, then you would already have access, and I could help you with that too. We do, just a reminder, we have the interpreter services, we've got the wire fraud protection, and I'm your go-to for lead generation, finding renters and homeowners. They're not live leads, but they are criteria that most match your target market. And I've been helping realtors and loan officers for the last 4 or 5 years with custom lead lists, very affordable, under $30 for 1,000 leads, some with phone numbers, some with not. But happy to meet for coffee or Zoom anytime on that.
Or happy to field questions, even if it's not my file. I get that as well. Yeah. Hey, you're not doing this closing, but this is what's happening, and I can't get like a straight answer from my title person. I can't get an answer at all. My title person's telling me this. Why do you think they're telling me that? Obviously, if it's not my file, I won't know exactly, but I can generally feel like I think this is what they're saying to you. This is what they're asking you to do. This is what they're asking from you. Happy to do that as well. So and then Randy and Jeremy, I would like to next time you would like us to pop on, I'd like to do a little quick claim deed presentation, because there's a whole lot of stuff going on with the quick claim deeds. I'm kind of happy that we didn't quite get to it at the end here, because it's not quite as easy and cut and dried as people would think. There's a lot of things to consider in the quick claim deeds. They're not, people think of them as kind of a throwaway. Definitely not a throwaway. A lot of considerations with that.
Yeah, definitely. If you want to, give this as a follow-up, so we could, I could forward that to the agents, or if you want to, schedule up another meeting if you want, that's fine as well. So
yeah, maybe down the road, Kathy will reach out, and if you're willing to let us come on, and I can come on and yammer around.
Of course.
On stuff. I'm willing to chat about all this stuff, but yeah, quick claim deeds are a big thing. There's a whole lot of things. It's become more of a thing lately where people are wanting to do that, and there's a lot of things to consider if you're going to do that.
Sounds good. Yeah, let's schedule it if you want. Let's talk about it. Thank you. Thanks, Jules. Thanks, Kathy.
Thank you so
for inviting us. We always appreciate your invitation to come on and chat with you guys.
Of course, you're welcome.
Have a wonderful week. Thank you.
Bye-bye.
Thanks, guys.
Bye.
Thank you.